Welcome to Sterling Insights, Stand Out and Supercharge Your Assets, the go-to podcast for financial advisors aiming to grow their assets under management, stand out in a crowded market, and retain assets nearly forever. Are you advising high net worth clients who own appreciated capital assets? Do you want to help them sell without losing a quarter, a third, or even more of their hard-earned profits to capital gains taxes? Then this podcast is tailored for you. Each episode brings you the latest strategies and expert advice from leading financial advisors, seasoned attorneys, and experienced CPAs. Learn how to maximize your clients' wealth, minimize their taxes, and supercharge your advisory practice with actionable insights. Join us on Sterling Insights, Stand Out and Supercharge Your Assets, where you'll gain the knowledge and tools to set yourself apart and achieve unparalleled success in wealth management. Subscribe now and empower your practice for a brighter, more prosperous future.
Welcome to Sterling Insights. It's good to have you on the program.
Thank you. I'm happy to be here.
So I'd like to ask you to step back in time a little bit and tell us how you got into law, what got you interested in law as a profession, and then tell us a little bit about your firm.
Sure. It's a little bit of a funny story. I was in college and I was going for an English degree. And my father, who taught middle school for, I think, 42 years, asked me if I was planning to be a teacher with my English degree. And I said no. And he said, you should probably find something else to do with it. So I decided to go to law school. I knew I wanted further education, and I thought law school was a nice fit for me. But when I started, I didn't have much experience in anything in the real world. So it's a process of search and find what would fit well with me and what I was interested in. And so I interned for a prosecutor's office. I interned for the city attorney in Chisago County. I interned with a law firm that did probate and estate planning. I found a niche in more of the civil and probate world. I really enjoyed meeting with clients, talking about their estate plan, talking about their future goals, whether they were a young family and they're just starting out, or whether they were in retirement or past that and planning for the end of their lives. And I also really enjoyed probate. I enjoyed working with families to administer the assets and finalize that plan that a family member put together however many years prior. So that's how I got started in estate planning and probate work. From there, I moved on to be in-house counsel for a client of mine. They had multiple businesses, and I served in their operations and general counsel. And after that, I met the firm I am now. I've been here for 12 years, and Mike and I, my partner, became partners about 4 years ago. So that's how point A to point B. Along the way, there were stops as working at the Capitol, stops and working in some other types of areas of law just to try them out, family law and some civil litigation. But I really found a niche, I feel like, in the estate planning and probate. And from there, I think it's blossomed out to what we do now at my firm is we do transactional work. We do business litigation, family law, and we also serve as fiduciaries, professional fiduciaries. So as professional trustees, professional personal representatives. So that makes up a good chunk of what our work is at our firm.
All right. I'm interested, and our listeners will be interested in that. I'm going to come back to that. I'm going to leave you with a little sidebar. I have a couple of kids who work in technology firms, both good writers, and really have advanced because of their writing ability. One of them is an English major, and I get all kinds of feedback that it's liberal arts skill sets that technology companies are very interested in.
Sure.
So I have lived personally in my family the benefits of an English major. I just thought I'd leave that with you. Tell me, because of our client base, we deal with people that have no will, they have children, they're in the later years of their profession, they have assets, no will, no trust. Could you comment on that? And then the really basic level conversation around wills and trusts, when they're appropriate, what have you learned? Stories, lessons learned with
Sure.
some of the estate planning issues that you've dealt with.
Sure. And I would say, especially in the topic of wills and trust, some of the, at least in my opinion and experience over the last handful of years, especially since COVID, some of the planning advice I think we give clients has changed, and I'll tell you why. Prior to COVID, especially in our role as a professional fiduciary, working with financial institutions, beneficiary designations, or working to attain account information was a lot easier and quicker done than COVID. Since COVID, that has become a much harder task to get the financial institutions of the world to follow along with beneficiary designations, keep things updated, work with their clients to update information. And so in response to that, I feel like we took a planning shift from being with our clients, and we still try to be, but be as practical and simple as possible, right? So if I have a house, a retirement account, maybe an investment account, something like that, and I'm saying, Scott, I want these assets to pass to my two kids equally, right? I think initially our planning step would be, let's talk about beneficiary designations and let's talk about a will. And the will is more of a safety net to say, if any asset titled in my name when I pass away is missed, if there's not a beneficiary designation, there's no joint titling, that asset will go through probate. Probate's just a process of retitling assets with the court, and that will direct where those assets will go. But primarily, we're relying on beneficiary designations because the client wanted to keep things more simple. I think since COVID, given some of the frustrations we've had at times with financial institutions, we've opted more for doing a rev trust and appointing the trust maybe as a beneficiary, or even when possible or when financially makes sense, retitling that asset into the trust. I was not a big revocable trust planner. It was more of the let's work to keep it simple. And if we're going to do trust, it'd be more around estate tax planning, irrevocable life insurance trusts or real estate trusts. But I think since COVID has made a lot of sense for a lot of our clients to set up revocable trusts now and point their assets with a beneficiary designation or retitling. And it's made it a lot simpler then after they've passed to administer those assets through the trust versus probate. I think probate gets a bad name. A lot of people are afraid of probate and they think probate is the government's going to take their money, or they think probate's going to take 2 years and cost a lot of money. And it can, but that's because it's being litigated, not because of probate itself. The probate process can be a little clunky at times, but really it's the court working with a personal representative to retitle and or administer and distribute assets. And it provides a nice way of giving notice to creditors, cutting off future debts, making sure there is someone appointed to handle final tax returns, pay off any liabilities, and then make distributions per that term of the individual's estate plan.
Okay. Scott, you mentioned some of the specialties in your firm. Could you revisit those? Just maybe pick up on 3 or 4 of the primary things you spend time on, and then give me an example of situations where it's worked well.
Sure.
Settlement of the estate, and other times it's been a difficult settlement, and why?
Sure. One of the main areas that we serve as a niche for our firm that a lot of other firms don't serve in this capacity is that professional fiduciary role. And a lot of times it's serving as a professional personal representative. And oftentimes we're brought into a case, not so much because maybe the person named me or our firm in their will, but because we have a situation where there may be complex assets. There may be complex business assets. We have an ongoing case now where we have an individual that owned a business with his son, and his half interest is having to be administered through probate. And currently the wife and the kids not of the marriage, the son that's running the business, aren't seeing eye to eye. And so you're serving in this capacity where you're trying to mediate the parties' conflict, trying to make sure that the business is operating at its best potential. And that's not only operations, but financial accounting, filing tax returns, and then making sure that we're doing our best to maximize the value of that asset so that when time comes to distribute, we as the professional fiduciary can show not only have we taken care of any issues or problems in that particular business, not only we tried to iron out or mediate out potential objections or fights between the family, but that we've improved value for the asset and we have something to distribute and account for with the court. So I think that's a unique service that we offer. The other times that we're brought in outside of complex assets might be interfamily fighting. There might be a personal representative named in a will. There might be no will. And so it goes by intestate succession, so basically by statute. And there might not be clear standing as to who should be that personal representative, or one family member may make allegations against another saying, hey, before mom died, you were her personal power of attorney, and we think you took money wrongly. We think you misapplied funds. We don't want you to be the PR. And so we're going to object to your position and bring in a neutral. And a lot of times the court, that's what they want to see. If there's going to be an objection, they would like to have a neutral party administering the assets. Looking at conflict between parties to say, in our position, we're neutral. We're not taking a side of anybody. I'm not advocating a position for a client. We're simply getting into the deceased's assets and looking at bank accounts, looking at investment accounts, looking at retirement accounts, securing the homestead where necessary, maybe ensuring that a family member that's living there has to be either evicted or removed from the home. Maybe it's securing a cabin property and ensuring that these assets are, one, protected throughout the process of the probate, and then two, administered either by liquidation or by distribution to individuals.
How do you, in that mediator role, when some of those family disputes are mom said or dad said issues and a sibling disagrees, how do you stay neutral? I know that's not a very well articulated question, but how do you stay neutral? And how do you get to facts that might be verbal?
Sure. So I think in the role of being an attorney, oftentimes you hire an attorney to advocate a position. It's not necessarily that attorney really takes an emotional tie into that position, but they're advocating the position for their client. I think it's very similar in the sense of being a neutral. You've hired me to take a position. That position is to sit in the middle and not be emotionally tied into what your brother did to you 20 years ago, or what mom did that was unfair when you were in junior high and your high school brother got to go to use the car or whatever it is. You take that position that I'm here to just be absolutely in the middle. And then it's talking with both the clients or all of the clients to say, guys, how can we come up with a solution that's going to best maximize the value for you out of this estate? When there's litigation, there's a fighting, especially in trust litigation or probate litigation, the people that often win are the attorneys. They're going to get paid out of the estate, and every dollar that gets paid towards those fees is going to lessen the distribution share that you're going to get as a beneficiary. And so talking with clients to say, how do we best understand our positions, where we're coming from, what the issue is, but what's going to be the most practical solution we can have in order to get you the most value out of this estate. And sometimes it seems a little bit counterintuitive to have a professional in that role, because obviously I'm charging by the hour for my services, but the time saved and the cost saved by having me, someone that has done hundreds of probates, been doing this for 15 years, know what he's doing, has seen different types of solutions, is going to end up saving you money rather than you all fighting in court, or rather than having, this is my favorite, is the sibling that's appointed or the family member appointed, and 3 years have gone by and nothing's happened. We have a case right now where there's a sibling appointed, there's a couple $1 million of farmland, it's been 4 years and nothing's happened. And so he's just sitting on the farmland. Our position, self-dealing with the farmland, but there's no action taken. So the value of the cash in hand for our client over that 4 years is exceedingly high, way higher than it's going to be to spend money on a fiduciary. And I think the other thing that we can offer there then is unique solutions, right? So I think we talked before, we had the cookie jar case. I had mom that had, I think, somewhere in the realm of 80 cookie jars. Now, these were decorative cookie jars. One was a Santa, one was a snowman, one was an Easter bunny. They're not of any value to anybody but for the family members, because this is what mom liked to collect. There was other miscellaneous personal property within the home that the family was also fighting over, but again, nothing of real value, right? So instead of litigating over personal property to the tune of $20,000, $30,000, $40,000 per family member, we had an internal family auction. And so we had an auctioneer come to the house, gather the assets, bring them to his facility. So there was a neutral place where everyone could come to. And the family members came to the auction and basically bid against each other for the assets that they wanted. And you're talking about bidding 50 cents, bidding $1. These are garage sale prices that they're bidding. But at the end of the day, they could spend their money in the way that they wanted. They could get the asset that they most valued from mom's estate. And it cost money to have the auctioneer there, it cost money to have me there. But that was small in comparison to what they would have spent litigating. So it's coming up with unique solutions because we've seen problems in the past. And then I think that, leads or guides some of our estate planning. We have our wills, and oftentimes there's 2 or 3 pages dealing with personal property. The client goes, well, my kids are fine. They're all going to agree everything's fine. Why do we need all this language? You need this language here because it's going to provide a pathway to resolve a potential problem in the future. It's going to cost a lot of money over assets that have no real monetary value. They may have emotional value, but no monetary value. So we want to set up a plan to make sure if this comes up, and again, everyone's family, no one's going to fight, but I have many attorneys here working on nothing but fighting through these estates. Let's have a plan to eliminate these problems and eliminate costs moving forward.
Is that solution or that approach typically driven by having schedules in the will or the trust?
I think it makes it a lot simpler because most times a lot of wills that we see are going to say, I have left a tangible personal property list. And that's a list where you're going to sign and date and say the lamp or the table goes to John Doe or Jane Doe. The most recent list is going to be what's controlling. A lot of times people say that in their will and they never do a list, right? And then it's going to say after that, the rest of my personal property will be distributed equally amongst my kids or distributed by the residue. It doesn't really lay out a pathway to value that personal property and especially emotionally value that within the family, right? Because that table or chair that is worth $3 at a garage sale and be valued for probably less than that if you got it appraised is worth the entire case to one of the kids because that was their favorite table or chair and that was their memories with mom. And so what we're trying to accomplish then in our estate planning is saying, how do we set up a process? Maybe it's an auction. Maybe it's everyone picks a number and you go 1, 2, 3, and then 3, 2, 1, and you go through the house and you pick out personal property. Or what are some solutions that we can enact that are going to be both practical, but also hopefully achieve clients' goals in distributing property and minimizing future conflict?
Okay. Let me go back to an earlier part of our conversation where you mentioned the complex assets and the separation of two business partners in the family. What does great planning look like for owners of private businesses? The buy-sell agreements is one well-publicized piece of that, but comment both on those agreements and what more comprehensive planning would look like.
I mean, documentation is key, right? And when I say documentation, I mean, you have your articles for your business, whether you're a corporation, you have articles in corporation, or you're an LLC, you have articles of organization, making sure you have your articles, your meeting minutes, making sure that there's probably an operating agreement or bylaws. So we talk about what voting looks like, what decision-making looks like. A buy-sell is a great document, but setting the buy-sell aside and saying, let's just say we were planning for a business that was 2 family members or a family friend and the deceased. Again, where we end up coming in is there's no documentation. There's no meeting minutes laying out who the officers are. There's no operating agreement saying how are we voting here? How are decisions made? Who has what role? Who has what authority? A very common issue we see with small businesses or family-owned businesses is lack of accounting controls, lack of accounting practices. Very often the business account is being used as a personal account. You're not probably always up to date on your taxes. And so again, making sure that if you're running a business, that you're running it like a business and not just a hobby that you're doing, and that you have your documentation. Because then when I step in and say, okay, I know what role John Doe is serving here, or I know that the tax returns are filed and that the accounting is correct, and I know that I can take this business, and if I need to, take it to a business evaluator who's going to put a value on this business for the probate court or for the trust administration. And then we know what we're talking about as far as value is concerned, or money, and making future distributions. The case I referenced earlier, due to the lack of accounting practices, it is very hard for a business valuation expert to come in and accurately put a value on this business. From there, I think it's planning then to say, all right, if we don't have a buy-sell and we're going to make a distribution of this asset through my estate plan, looking at who that asset's going to, right? So if you're the business owner and you have maybe 3 kids and a predeceased spouse, saying, I'm just going to distribute everything equally. Well, maybe it doesn't work here, right? Because maybe one kid is very involved in the business and the other 2 don't care about it, right? And so that one kid is going to overvalue that interest because this is their livelihood, where the other 2 might use it as leverage to gain something else that they want. You're setting up a potential fight because you're not looking at the distribution in a way that makes the most sense for the beneficiaries, right? So if we said, I'm going to make a distribution of my business interest to son 1, but I'm going to give an offset because I have valued what this business is, I'm going to give an offsetting distribution to kid 2 and kid 3, right? And once those are all satisfied, if there's anything left in my estate, great, we'll do an equal distribution at that point, right? But it's having some of those unique planning measures to say, how do we get the correct asset maybe to the correct person from a value standpoint, right? And then how do we make sure that if we're going to be equal, if that's the plan, that we equalize out with maybe a retirement account, right? And so if we're looking at that retirement account, we might need to say, we know when we take money out of that account, it'll be taxable. So we have to probably gross up or account for the value in that retirement account versus the value of a business versus maybe a family cabin that you're giving to a third child that you know will take a stepped up basis in value at death. And so you're gonna have a lot less tax outcomes there. So it's understanding the value of the asset, who's gonna best maximize that value, who wants it the most, and then how do we best equalize that moving forward. So I think when you're planning for a business, those are all the really key elements in a way to minimize potential conflict. The other way is, I think what you reference is the buy-sell. Buy-sell agreement is a great way of protecting probably business partners from each other's families a little bit, and a great way of laying out exactly how this business interest will be distributed upon death. Also in divorces, it really is effective there. But I think from the passing standpoint, when someone dies and saying, we know there's going to be a probate of this asset, or we know this asset would have otherwise transferred via beneficiary designation, and we know we have a document that says, when someone dies, here is the exact process of valuing that interest. Here is what the payoff is going to look like. Here are those payment terms. And potentially, here's a promissory note, or here's some sort of other financing security documents that we're going to have to ensure those payments are made from the business to the either estate or beneficiary. It just smooths out the process and again eliminates the opportunity, hopefully, for conflict moving forward.
Okay. When we see wills and trusts, a typical situation that we would see is a couple, long married couple owns a business. It's often in the name of the man, the husband. They have a trust, and ownership of the assets, including the business, are funded to the trust. If that owner passes away unexpectedly, that asset transfers to the spouse in its entirety. And now we still have a family situation in terms of transfer, valuation, all of the issues that you raised about that business. I know it's a situational question, and I know it's a very general question, but what I'm going back to business planning, because it's a complex asset. It's an example of a complex asset. What does that trust look like? What might it look like if we used a typical situation that you deal with in your firm?
Sure. So I think the first step there for me is looking at how is the entity taxed, right? So let's say it's the husband that owned the entity, and let's say it was a disregarded entity and just passed through to their Schedule C, right? From a tax standpoint, that passing to the trust is going to be okay, right? We're going to have questions on let's minimize income incurred in this trust given the rates of trust and what you're going to pay in taxes. But we can have a trust manage that asset. That's fine. Versus if husband was taxed as an S corporation and that asset passes to the trust, we're going to have to make a Q sub election. We're going to have to be a QSST. And what does that mean for administration? And what does that mean for the overall value of that asset and the cost of doing that moving forward? And do the trust terms, are they planned for that? And a lot of people, oh, here's your general trust. And then we don't really pay attention to the assets we're necessarily putting in there or the tax outcomes of putting those assets in there. And maybe we don't have the correct terms in this trust to be treated as a QSST. So I think there's a planning stage there. There's also the look of, and we've seen this a lot too, of maybe a husband owned an insurance agency, right? And so he has a license or he has an agreement with farmers or whoever it is. And when that asset passes to the trust, that's fine. But the person who's either the trustee or the person to receive that asset at the end of the day isn't going to have the proper licenses to actually run the business, or isn't going to be allowed by the maybe franchisor or person holding the total business there, the book of business, to actually run and do the business. And so you have to make a determination of, if I'm going to point this asset to the trust, is this even going to be a workable solution? And if it's going to be, no, this isn't workable. We've seen this where an insurance agency comes to mind, because we've had this case where a husband passed away, had an insurance agency, the insurance agency passed to the trust. And it was basically then terms in that trust for the spouse to sell the book of business so that she could recoup funds and use funds moving forward. There wasn't ever the plan for the spouse to step in and run the business because she didn't have the necessary abilities to do that. So when sitting down with that business owner and saying, one, how are we treated from a tax standpoint? Two, if this asset does transfer to a trust, does that trust joint with spouse? Does that trust become irrevocable? What's that going to mean for your overall business operations? both from the licensing standpoint, franchising standpoint, potentially ongoing contracts. Is the contracts that you have to provide services, is that going to treat it as a transfer? And if so, will that void the contract? So I think it's walking through all the kind of operational pieces with the business. And then you get to, what are the terms of the trust? Is it practical for this trust to manage this business? And what is this beneficiary or trustee? Do they have the abilities? Right? If we transfer a business that there's no tax issues, there's no operational issues into a trust, but the trustee here is completely devoid of business knowledge, business acumen, is that the best idea? Or if it's a business that's highly speculative, is that trustee going to look at that business and say, as the fiduciary here, I may have to liquidate this asset because I don't think I'm following my fiduciary duty by having a highly speculative business and trust. I need to liquidate, get cash, and invest that cash in a stable investment vehicle. And we've got a case right now where the trust holds a lot of real property, a lot of rental property. And we're the trustee on that. I've got two of those actually. And in one of them, the renters in some of the cases are moving out, and I'll be liquidating those homes and reinvesting those funds from the liquidation into investments. Because for me, having a house that has a 25-year-old roof and a 20-year-old boiler is not a great investment. It's not a good thing for me as a fiduciary, because as these things break down, I either drop value significantly because I have a non-performing asset, or I have to invest funds from the trust into an asset that I may not see the return on given where the location is. And I think on the other side of it, it can be a profitable asset, especially as rates are high, you're not getting maybe a high return on interest. And so rent can be a nice investment vehicle at times, but you have to weigh out the market of what am I going to see in a return on investment versus what am I going to see in rent, that net revenue plus risk, right? What cost do I have to start setting aside to make sure that I'm covering for an emergency, make sure I'm covering for that new roof or a septic issue or what may come up. I think it's really evaluating what are the assets in the trust and are these going to be good assets to hold.
You've given some examples of the financial organization and valuation of a business. Does your firm have internal capacity for accounting and valuation kinds of issues? If you, to the extent that you do, describe those, and to the extent that you don't, how do you interact with those firms?
Sure. So I think from a business valuation standpoint, we're not going to be the firm or the company to do the valuation. We usually send that out to a third-party company who's then going to stand behind that valuation.
Right.
One, from a litigation standpoint, if they ever need to be a witness, they need to be called in. It can't be us. Two, from an audit perspective, whether it's Department of Revenue, IRS, they're going to stand behind that valuation. If we get audited, we can point to them.
Right.
So we send the valuation out. From the accounting standpoint, our firm does 1041s. Those are trust or estate income tax returns. We do 706s, they're estate returns. We'll generally do final 1040s, so maybe a 1040 for a deceased. We do trust accounting. We do accounting through our probates. And then we office share actually with an accounting firm that can do business returns and do 1040s and do any other accounting work or bookkeeping work. So it's nice to have that capacity internal so that we can make sure that when we go to the business valuator, we can give them the assets that are in the probate, the assets that are in the trust. We can hand them hopefully a pretty clean accounting, up-to-date tax return. So really they're just evaluating what that asset is worth or what the ongoing business is worth.
Okay. How do clients find you?
We have a website. I don't know, it's always best marketed, but we do have a website. But a lot of our referrals, honestly, are from other attorneys, other accountants, and returning business. I have a lot of people have contacted me to say, hey, attorney told me to call you, or my accountant said, we're going through a tax audit. Reach out to you guys because you're going to help us with the tax controversy piece here. Financial planners, other professionals. Always a good way for us to get referrals. We really try to position ourselves as the attorneys that are going to be practical and really understand business, tax, and probate. It's not me just handing you a 40-page will that it's in a leather-bound book that I'm going to charge a flat rate for and just I'm spitting these things out over and over again. We're really going to sit down and try to work with you to understand what your goals are, draft up a plan, explain that plan to you in a way that you're understanding when you leave my office, and then that plan is going to be practical in its execution. And I say practical in the execution because I think that's also guiding or advising the client on, you can have your goals and I can draft for just about anything, but does this make sense after you pass away? And I say that because we've got a case right now where there's a trust, and the trust has some financial assets and one piece of real estate. And unbeknownst to the trustor, the person that set it up, there is two revisions to that trust. One of them is missing. And because one of them is missing, we're in Hawaii land court because it's a Hawaii condo. Before we get to Hawaii probate court, in order to point the asset back to the trust originally, we've had to go through many steps and get a declaratory judgment here in Minnesota because this information is missing. But let's just say that didn't exist and it just ran smoothly. There's 47 beneficiaries in this trust. Now, if you had a $100 million trust, would that maybe make some sense or be worthwhile on the administrative side? Maybe. This is a nice trust. It's $1.5 million or something like that. But there's 47 different people that we've had to give many notices to throughout this entire process because of all the steps we've had to take. We also have the cases where maybe the grandpa puts in his will that he wants granddaughter to get $100. That's nice, but actually practically thinking that through to say we're in probate and I have to track down granddaughter who's in Colorado to mail her a $100 check. What's the cost going to be of the administration to do that? It may seem nice, it may seem like a gift, but what's the cost? What's the practicality of doing this? And so sitting down with clients and saying, one, when you leave my office, you're going to understand what your will says. You're going to understand what your estate plan says. But two, it's going to be practical in its approach, right? That doesn't mean you can't have what you want, but let's actually talk through what's going to happen when you die and how do we go from point A, your death, to point B, assets are distributed. What does that process actually look like? And I think clients are a lot of times surprised by that. I think they don't understand maybe all the steps it's going to take to administer their estate or administer their trust. And it's bringing them back down to say, oh, I didn't realize you're going to take 17 steps to kick out $100. Let's not do that. Let's find a different way to make a gift or make a distribution through my estate.
I'm going to ask a final question at a really detailed level. We get asked about wills for people that we're doing planning with. If they don't have a will, they want one drafted. They understand what a will is, or they certainly can read endless articles about wills. But it's difficult for those of us that don't practice in estate planning as you do. What does day one, week one, month one look like in the settlement of an estate? Is it a meeting with the probate court? Is probate court meeting always involve the judge? What does that specific set of interactions look like?
Sure. So I think the first step is having your client understand what a will does. So most people think, I have a will, I don't have to go through probate. That's not it. Your will is going to be your roadmap for explaining or showing where your assets go. And so it's figuring out how are assets titled, are there beneficiary designations? If no to both of these, then our will is going to say where they're going to go, and that's going to be probated. And probate is just really a matter of retitling assets, right? And that's what the court's doing. So if we have assets that need to be probated, and we have a will separate from intestate succession, we have a will that says where things are going to go, you're going to come into my office and we're going to say, great, let's get a summary asset list as best we can, because you may not have all the information. You don't know everything mom had. Let's try to walk through what the debts might look like. Is there a mortgage? Is there outstanding credit cards? What are the non-probate assets? Maybe there's a life insurance policy that passes via beneficiary designation. And then let's have the personal representative of this will agree that they want to serve in this role, right? Once we have that information, we're going to draft up our petition, our court order, all of our notices, our acceptances, so on, and we're going to file those with the probate court. And so there's two different pathways from there. So once we have all this information, there's a pathway called informal probate. An informal probate is you submit your will and all your documents to a registrar. And that's going to be a fairly quick process. The registrar is going to review, as long as everything's in line, they'll sign off, and you'll have your personal representative appointed, and they can administer your estate. I don't particularly like that process all that well, simply because a lot of times people, if they don't have a sense of formality, if they don't have a sense that, well, there's a judge here and they're going to review things, they don't get things done. And the last informal probate I did was one asset. Dad had beneficiaries on everything else. He missed this asset. Unfortunately for Dad, the asset was over the minimum of $75,000. It was like $82,000. And so the daughters, who split everything else 50-50 beneficiary-wise, had to probate this one asset. And so I said, great, you guys are getting along, everything's 50-50, simple asset, we'll do it informal. 2 years after the fact, I'm still getting notices from the financial firm because nothing's been done with this account. They just never followed through on it because it just wasn't a real thing for them. They never took it seriously. There's nothing tangible there. And the court, in that sense, isn't going to be looking for more information. Once an informal probate is open and someone's appointed, they close it. So it's a done deal. It's not a done deal. It's step one. You still have to do all the steps after it. So the other option is going formal. If you go formal, there's unsupervised and supervised. A lot of times we go formal, unsupervised, where we submit all of our documentation to the court. The court sets a hearing, and depending on the county that you're in, that hearing might be a couple weeks out. That hearing might be a couple months out. So Hennepin, Ramsey are more a couple months, whereas like Dakota or Scott County or Goodhue County might be a month or less. You're gonna have this hearing, and for most counties, you're going to show up via Zoom now, thanks for COVID and having everything online. Instead of driving to these courthouses, you're going to show up online, and you're going to be in front of a judge, and you're going to say, here's our petition. Maybe the judge wants you to prove the petition on the record, walk through it, or maybe they'll just allow it to stand. But a judge should say, great, everything's here. All notices have been given. I'm going to sign an order, and I'm going to appoint a personal representative. And that's always the first step. From there, once the creditor notice period is set when you file, you've got 4 months. There's a creditor notice period. Creditors can give notice to the estate, or if you're a fiduciary and you're aware of a debt, these are the debts that are going to get paid through the probate, barring some exempt assets. So you have to kind of let that period run. During that time, you can take action. You can sell the house. You can maybe collect the bank account, sell the vehicle, do all those things, but you can't make distributions until that period is run. Once that period is run, then you can start talking about, let's make sure our inventory is correct, right? All the assets are listed and all the values are accounted for as of date of death. And let's make sure our final account is correct. Well, here's our inventory start date. Here's all the assets we have. Here's the expenses that we've paid. Here's what's left over for the distribution. Whether or not you end up submitting that inventory and final account to the court, our office always does that, because we want to make sure we have a complete record from start to finish of what happened when we started with these assets and where do these assets end up. From there, you're either petitioning the court to close out the probate, dismiss the personal representative, make distributions, or some counties don't, if it's formal, unsupervised, don't want you to anymore. And so you'll follow that process and get receipts and make the distributions. And that process from start to finish, I think if you're really running pretty well and there's not a lot of fighting, 6 to 8 months is probably what you're looking at. A year is probably more average. Formal supervised is another process. That's where basically everything I described, but every time you want to do something, you're going to get a court order. And then that process can run about the same time frame. Lastly, you have a probate or trust administration, and there's fighting, there's litigation, right? And that can go years. The horror stories from your neighbor that you read on Google, it's not probate, it's litigation. And so it's how long do we want to fight? And you could file, and you could file an objection from the other party. You could set it for a future evidentiary hearing, and that could go 3 or 4 hearings, right? We're talking months and months and months of full-on discovery, depositions, going through what actually happened with the assets, and then presenting your evidence to the court. And so that can be very expensive in several years worth of time.
Yeah. Those are unfortunate in almost all cases. Those are unfortunate. Yeah. I've been through a couple of business separations that weren't litigated to that extent, but partners who worked together successfully for 10 years. One's going to retire, one becomes ill, and suddenly they're on different sides of a transaction.
Yeah. And we do business litigation, we do shareholder litigation here too. And it's at some level, it's kind of that same with probate litigation. Who wins is generally the attorneys, right? If we're going to litigate and spend all this money, we'll do fine. It's the business that is left up to pick up the pieces of, can we afford to do this? Or the family to pick up the pieces of, all right, now I'm not talking to 2 of my brothers for the next 10 years because we spent 2 years in court fighting each other, spending $100,000. Nobody wants that. Trying to find those practical resolutions before we get to that point is really where we try to position ourselves.
Sure. Scott, a lot of information. You're a deep firm. How can people find you? Provide your contact information and direct them to you. Keep in mind, we have listeners outside of Minnesota.
Sure.
So let us know where you are.
So we have an office in Eagan, Minnesota, and Cannon Falls, Minnesota. Our website is Kennedy and Ruhsam. I believe it's www.mpkennedylaw.com. If anyone has questions or wants to reach out to me personally, direct line is 651-262-2085. And email is scott.ruhsam, that's RUHSAM, at mpkennedylaw.com. And if you're we are licensed in Minnesota. Anyone in Minnesota is happy to help them. If you're outside of Minnesota, there's still things we can help you with, whether it's tax resolution, tax planning, We have people outside Minnesota that use us for federal tax audits, even state tax audits. Don't be hesitant to call and reach out with questions. And if we can't help you, we'll certainly find someone that can.
Great. Thanks for your time.
Thank you. This has been a lot of fun.
It was interesting, and we'll direct people that might come our way through Sterling Insights. We'll direct them to you.
Perfect. Sounds good.
Thanks, Scott.
Thank you.
Bye-bye.
Bye.
Thank you for listening to another episode of Sterling Insights. Stand out and supercharge your assets, where we provide the info you need from successful leading financial advisors, lawyers, and CPAs. Your hosts, Roger and Catherine Silk, invite you to learn more about Sterling Foundation Management by visiting sterlingfoundations.com.